The purpose of following current affairs from Indian polity is to make sure that your preparation for our examination is aligned with what is necessary as part of the demand of the examination. Today, we will be discussing about most of the important topics from the last week's current affairs from the subject Indian polity. Hello, welcome to another episode of Current Affairs from Amrita IAS Academy. I am Manisham Nambiyar, Faculty for Indian Polity. Starting with the topics for the day, the first news is one of the most important news which I have seen in a while. The news was that the chairperson of the State Public Service Commission for the state of Karnataka was suspended by the governor of Karnataka, and the governor of Karnataka forwarded a letter to the President of India. So we need to know what happened there, what was the issue, and what could happen now. So the issue started with an allegation, and the allegation was that the daughter of the chairperson of the state PSC of Karnataka had secured a job which was conducted, an examination which was conducted by the state PSC of Karnataka. Actually, that was not the most important case. The allegation was that that particular candidate had obtained an OBC non-creamy layer certificate which was obtained through fraudulent means, which means she declared an income which was much lower than what actually was. And because of that reason, it was found that the particular candidate is not eligible for the appointment, and yet she was given appointed. Now raises the question, the father of a candidate is working as the chairperson of a body which is recruiting the candidates for the particular post. So when a member of the family is attending an examination, two questions comes. What about the legality and what about the morality? That was the question here. And based on that, the governor of Karnataka had now acted with a firm hand and said that the action from the side of the chairperson of the state PSC was wrong. And now the governor had requested the president to remove the chairperson of the state PSC. Now raises the question, the chairperson of that particular PSC, Public Service Commission, was appointed by the governor. The person was appointed by governor. But for the removal, now the governor is requesting the president for the removal. Why so? Let us look into the details of what Article 317 has to speak about it. So Article 317 of the Constitution says that any member or chairperson of a public service commission, be it the Union Public Service Commission or be it the State Public Service Commission or be it a joint public service commission, shall be removed from office only by the President of India. So be it a member of the UPSC or State PSC, removal is done or removal can be done only by the President of India. So that is the first thing which we need to take care. Even though the members of the state PSC and the chairperson of the state PSC are appointed by the governor, the removal is done only by the President of India. That is the first thing which you need to understand. Now, there are two situations in which a member or the chairperson of the PSC can be removed. First situation is due to misbehavior. Under the second situation, there are three more situations which are present. The first one is the person becomes an insolvent. In the sense, the person is no more financially stable to continue to the post. There can be chances of graft. That is the idea. Then, the member or the chairperson finds a job outside this particular post while the person is continuing in the particular post. Next one, mentally unfit. The person is no more fit to continue in this post. So these are the two conditions, or mainly we can say four conditions, but three of them are categorized together. So these are the broadly two conditions in which a member or the chairperson of the PSC can be removed. And in these cases, the Constitution of India says that in case number 1, when the member is to be removed on the reasons of misbehavior, the president has to act on the advice of the Supreme Court of India, which means the President has to refer this matter to the Supreme Court of India, and based on the particular matter, the Supreme Court has to form a committee and form a judging panel, and they have to then give a decision back to the President, and then only the President will be able to remove the person. And the interesting situation here is that the advice given by the Supreme Court in this matter, it is not considered as the advisory jurisdiction as under 143, but in this matter the advice is binding on the President. Only based on the opinion given by the Supreme Court, the President can continue the action. So, for misbehavior, President can remove the member or the chairperson based on the advice of the Supreme Court. Now, for the rest of the three matters, in this case, President can remove them without even getting the advice from the side of the Supreme Court. So, now you know what can happen if a member or the chairperson of the Public Service Commission, be it at the center or be it at the state, is to be removed. Now, in this particular case, with respect to the chairperson of the Karnataka Public Service Commission, the governor had recommended to the President that this particular action from the side of the chairperson of Karnataka State PSE can be considered as misbehavior, and the governor of Karnataka has now requested the President of India to refer this matter to the Supreme Court. So, now let us wait and see what is going to happen in this particular matter. And now you know what can be done if there is any misbehavior or if there is any misconduct from the side of any of the members of any of the public service commissions, be it the state commission or be it the Union Public Service Commission. Now, moving on to the next most important news from last week. A new chairperson was appointed to the Minorities Commission. That was what caught my attention. So, there is a commission known as National Minorities Commission. So, today I want to discuss about the National Minorities Commission, and also I want to discuss about another commission which has somewhat similar works but in an entirely different manner. Okay. So, starting with Harjit Singh Grewal was appointed as the new chairperson of the Minorities Commission. Okay, fine, totally fine. And the appointment was done by the central government. You need to understand something. The person was not appointed by the President of India. The person was appointed by the central government. You need to keep that in mind. Now, let us discuss about the National Minorities Commission and their functioning and their powers and their status. So, in 1978, the National Commission for Minorities were appointed through an executive order of the Government of India. Since the Government of India felt that the minority communities in India are facing some issues and their development is not happening adequately, the National Commission for Minorities were appointed for the purpose of welfare, for the purpose of giving suggestions and for guiding the government and to take care with respect to the policies of implementation. It was created as an executive body in 1978. Okay. Then later, in 1988, something new happened. So, before going to discuss about what happened in 1988, I would like to discuss few things about the term minorities. So, with respect to the Constitution of India, the term minorities are mentioned at different places. Specifically, if you look at Article 29, Article 30, among the fundamental rights itself, the term minorities are mentioned. But the issue with the Constitution and the provisions of the Constitution is that the term minorities are not defined in the Constitution of India. See, that is the drawback which we feel with respect to the Constitution and the term minorities. It is not defined in the Constitution of India, even though it is mentioned in different places. And now we need to look into, that was the issue for the Government of India too. Be it in 1978 when the National Commission for Minorities was created, or be it in 1988 when we are about to discuss something which happened then. In all these cases, the issue was that the term minorities was not defined anywhere. And if you look at Article 29, in Article 29, the Constitution is speaking about two types of minorities. One is religious minority and the next one is linguistic minority. because Article 29 is speaking any section of Indian citizens. So that was the Article 29. So there was an ambiguity whether NCM should look into the activities of religious minorities and linguistic minorities. That was the question. So in 1988, Government of India, through a subsequent declaration, through an executive order, clarified that NCM, that is the National Commission for Minorities, shall only handle the matters of religious minorities and not linguistic minorities. So that was clarified by the Government of India. Then later in 1992, the National Commission for Minorities Act was passed, and through this particular act, the National Commission for Minorities, which was an executive body, was elevated to the status of a statutory body, and in 1993, National Commission for Minorities were constituted, which means in 1992 NCM Act it was given the status, and 1993 it was properly constituted as a statutory body. So this is the history with respect to National Commission for Minorities. And now you know few things about National Commission for Minorities. It will look only into the matters of religious minorities and not linguistic minorities. Then you know that within the constitution the term minorities are not defined, but under Article 29 and 30 you know that there are some references with respect to minorities. Then National Commission for Minorities is a statutory body. So this is what which we understand from the discussion in these two slides. And there is also one more thing which I want to take. According to the National Commission for Minorities Act, this particular act specifies that the minorities in India shall be notified. They shall be notified by the Government of India. Okay. So who all are minority communities in India shall be notified by the Government of India. And accordingly, 6 religious communities has been notified as minority communities in India: Muslim, Christian, Sikh, Buddhist, Jain and Parsi. Parsi is a community which is also known as Zoroastrians. Okay. So these are the 6 religions which are recognized and notified by the Government of India as minorities in India. So which also means the National Commission for Minorities, which is a statutory body, is duty bound to look into the matters only of these 6 communities in India. And when the members are appointed, they are appointed for a term of 3 years. The commission consists of 1 chairperson and a maximum of other 7 members, which means the total strength of the commission is 8. There shall be maximum of 8 members in the commission. So this is what I wanted to discuss with you with respect to the National Commission for Minorities. Now, just like National Commission for the Minorities, there is also another organization which is known as the National Commission for Backward Classes. So why do we have a National Commission for Backward Classes? So National Commission for Backward Classes was also a statutory body previously. Then later it was given the status of a constitutional body. So the duty of National Commission for Backward Classes is similar to that of National Commission for Minorities, but the difference is that National Commission for Minorities, which is a statutory body, can look into the matters of only 6 religions in India, whereas National Commission for Backward Classes, it deals with the matters of every backward class in India, which may or may not include these 6 religions. Okay, so that is a basic difference. And the National Commission for Backward Classes is a constitutional body. It is not just a statutory body. And there are few other differences too, which I will leave to you, a homework for your own. You have to do that work. Okay, so now moving on to the last news which I am about to discuss. There was a term in news, trial in absentia. So why this particular term was there in news? So there is a terrorist who has been declared both by India and United Nations as a terrorist, global terrorist. His name is Hafiz Saeed. He was the mastermind behind the Mumbai terror attacks of 2008. So the case is ongoing in the NIA court, National Investigation Agency court, in which Hafiz Saeed is an accused. And what is the issue? Hafiz Saeed is not presenting himself or not being represented through an advocate before the court. So now what is happening? One party to the case, that is Government of India, is present. whereas the accused, that is 𝐴𝐵𝐴 or nor his advocate is present in the court for the procedure. And because of this reason, what is happening? The case is getting delayed and justice to the victims are not being done. Now, an extraordinary power of the judiciary has been taken and utilized in this particular situation, and that is known as trial in absentia. So, this particular section of the law says that even without the presence of the accused, a case can be continued, it can be heard, the judgment can be given, and the conviction can be delivered even without hearing the particular accused in the matter. So, that is simply speaking the concept known as trial in absentia. So, now we need to know from where does the judicial system gets this extraordinary powers of criminal conviction. So, there comes two sections of Bharatiya Nagarik Suraksha Sanhita, that is the BNSS, which has replaced the CRPC previously. So, section 356 of BNSS speaks about trial in absentia, but at the same time there is a slightly contradicting or confusing section, that is section 351 of the Bharatiya Nagarik Suraksha Sanhita. So, I will discuss to you what it means. So, under 351, section 351 of BNSS, it says that no person shall be trialed in a court of law without hearing them, or in other words to speak, every accused has the right to be heard in a court of law, which means before giving a verdict in a particular case, each and every party to this particular case should be heard. The victim should be heard, the police should be heard, the accused should be heard, other witnesses should be heard. Only then the court is having the power to declare a particular person as innocent or convict. So, that is what law says, and this particular concept Audi, Alteram, Partem, that is the actual term which we use, and this is part of the principles of natural justice. So, it is part of the principles of natural justice. So, that is section 351 of BNSS for you. It is a direction and it is a guideline to the court which says that without hearing the accused and without hearing the all parties of the case, no judgment shall be made. Whereas, now section 356 of the same law says that even without hearing the accused, even without the presence of the accused, the case can be heard and judgment can be delivered. So, now don't you think section 351 is in contradiction with section 356? Peripherally looking at the matter, yes. But why do we have this particular concept of Audi, Alteram, Partem as part of our criminal law? This is to ensure natural justice. Here what we are making sure is that even a person who is accused is given the right to prove himself or herself innocent. So, we are giving them an opportunity so that complete delivery of justice can be done. But now in the case of 𝐴𝐵𝐴, what is happening now? Since the person is absent in the court of law, since no one is representing 𝐴𝐵𝐴 in the court of law, one party to the case is absent, and because of this reason, the case is still ongoing. Now, what about the justice which was necessary for the victim? Victim also deems some justice. The nation also wants the justice. So, in this situation, there comes the role of section 356 and trial in absentia so that complete justice can be ensured. So, trial in absentia essentially gives the extraordinary powers of the court to continue with the proceedings when the accused or the parties are not cooperating with the case. So, in this particular case, since the parties are not cooperating, we assume the system assumes it as a waiver of the rights. See, section 351 granted each and every person a right to be heard, before the court of law, before the judgment. But since the person is now not cooperating with the investigation, it means that the person had recused or maybe said that I don't want that particular right to be heard. I am not ready to speak with you. So, now the system is assuming that yes, the person had waived his or her rights. Now, since the person has waived the rights, now the judiciary can continue with the process. And according to section 356 of the BNSS, there are some conditions also. First, the court has to issue a warrant of arrest. Warrant of arrest towards the accused. Then, if the accused is not being arrested by the police, or if the accused is not presenting himself directly or through an advocate, minimum after a gap of 30 days, another warrant has to be issued. Okay, so that is the first step. The 2 consecutive warrants of arrest has to be declared with a minimum span of 30 days, which means the court is first giving the accused an opportunity of 30 days. So 30 days opportunity has been given for the accused to present himself or herself before the court. Now comes the next step. After the direction of the court, the executive, that is a police, has to give an advertisement in the local newspaper, and this local newspaper should be circulated in the place where the accused is known to have to be living there. So എവിടെയാണോ accused താമസിച്ചിരുന്നത്, അല്ലെങ്കിൽ നമ്മുടെ അറിവ് പ്രകാരം accused എവിടെ നിന്നാണോ, in that local newspaper an advertisement has to be circulated. So that is the second condition. So what we are ensuring, we are making sure that if in case the accused was not aware of what is happening, now the accused should be made aware of the matter. Now comes the third condition, that is information dissemination. When the charge sheet is being filed or when the investigation is ongoing, the police will know in which all addresses the particular accused had resided previously. So now comes the third step, which is proclaimed or maybe declared under section 356 of the BNSS. It says that in all these addresses, a lookout notice has to be published by the police system, and the friends, family members and each and every person who is known to have some relation with this particular accused should be informed of the matter, and they should be conveying it to the accused that a case is ongoing, you have to present yourself before there. So only after when these 3 situations are done, and after a total of 90 days from the filing of the charge sheet, the court can continue with the idea of trial in absentia. So now you know what can happen when a person is not cooperating with the case, and when a person is trying to deliberately avoid the criminal justice system of Indian judiciary. So with that, the idea of justice is being ensured, and with that, people, the victims, are being delivered what was rightfully theirs, what was guaranteed by the constitution, what was guaranteed by the law. So now you know what could happen in these situations. I hope you understood the concepts which we have discussed. Thank you and have a nice day.
Amrita IAS Academy.